Well, I don't see it, but it's in the matter of the marriage of Kelly Hettinger and Andrew Hettinger in the interest of children. It's
Clause number
0907-19-8. Is that right?
That's correct, Your Honor.
Okay, so here we are. I think what was scheduled for today is a motion for enforcement.
That's correct, Your Honor. And that was reset from our December setting. It was reset to January.
Okay.
But we got word the other day from the coordinator that you just wanted a status hearing today.
Well, what I wanted was whatever was set for today, that's fine. But I wanted to know what else is out there that's pending. I wanted a list from each side as to whatever pending motions you want heard and on what day they were filed, so that Ms. Bettis could get me a copy of that so that I could go through it with you today and figure out exactly what we need to get heard, how long it's going to take, and then set a time to hear it so that we can get this thing in front of a jury and get resolved once and for all for these people.
And Mr. Hull and I both did comply with that. Okay. He sent his January 13 and I sent mine January 14.
But Judge, can I talk to you for just a second?
Sure.
Yeah, we previously, as you know, mediated the case. We had a mediation, it didn't work. And then the mediator sent a mediator proposal with two options. Both sides accepted the same option. So I don't know why we haven't just worked out the final details. We
did not accept the mediator's proposal.
Judge, I have a letter from their office saying we accept proposal 2. We also sent a letter saying we accept proposal number 2.
No.
I can send those to you.
There is no Rule 11 agreement settling the case, Your Honor. We'd like to have the motions heard. I mean, if Mr. Hull thinks that he has an enforceable Rule 11 agreement, he can file a motion.
I don't think that's what he's saying. He just, from what I understand, is it sounds like maybe y'all agreed to the same thing and just haven't communicated that to each other.
No, Your Honor, we have not agreed to the mediator's proposal. In fact, we sent a proposal of settlement to Mr. Hull, and he told me that it was not worthy of a response. He prepared his mediated settlement agreement, which was not the same as what the mediator had proposed. And I prepared my mediated settlement agreement and sent it to him, and he said it was not worthy of a response. So obviously, we are not on the same page.
Judge, I have in front of me a letter dated September 23rd on Dale and Klein letter saying, "Dear Judge Alejandro, please allow this letter to serve as Ms. Hettinger's response. She will accept proposal number 2. And then we also sent a letter saying we will accept proposal number 2. What I did was then drafted a mediated settlement agreement so we could try to work out the fine details. Ms. Klein said, I think we're close. We've got a few changes. And then she added like $200,000 in attorney's fees and different things and everything like that. I think perhaps maybe if the court could set us back with Judge Alejandro, since everybody accepted his second proposal, and see if we can't work out the fine details.
The problem, Your Honor, is that my client has not received any spousal support in over a year, and Mr. Hettinger believes that he has no obligation to pay the court-ordered $10,000 per month, which Your Honor ordered in the order that you hand wrote all over and signed on the 30th day of October 2020. Mr. Hettinger has decided that those orders no longer apply. You ordered him not only in writing, but on the screen, not to have the children around his paramour. He had Thanksgiving dinner with the paramour and with the kids. You've told him not to engage in unnecessary travel. He's been to Iceland. We understand, has been to Antarctica. The orders that the court has made seem to have no, Mr. Hettinger thinks it's funny, but Mr. Hettinger seems to think that these orders don't apply to him. Page 4 of 9 says, pursuant to the agreement, except as otherwise provided in this order, Andrew Hettinger shall pay consolidated interim temporary child and spousal support totaling $10,000 per month to Kelly Hettinger for support of herself and the children, period. He unilaterally decided, after we went to mediation and didn't settle, that he, according to him on advice of counsel, only needed to pay $2,300 per month. So my client has been getting $2,300 per month instead of $10,000 per month when there is no order modifying support. And that's why we have been seeking, Your Honor, sadly, for many, many months to have an order signed by Your Honor, which has apparently been something that we've been unable to do. We've been trying to get an order to show cause signed and served on Mr. Hettinger, and it's been reset several times, and we can't get this matter heard. And so my client, Mr. Hettinger, is taking out $400,000 a year. He's taking $30,000 a month for himself. And my client is expected to support herself and 3 children, including the one who's gone to college, on $2,300 a month.
Judge,
This
if I
is
can respond,
just not equitable.
Judge, if I could respond, first of all,
Hold on. I don't know what she's done.
No, I'm not, because of the fact that, Your Honor, we have been trying since we filed this in October of 21. We've been trying for the last year to get a setting on a motion for enforcement. And with all due respect, Judge, we had a setting in December. We couldn't get the order to show cause signed. We had a setting in January. We couldn't get the order to show cause signed. And the dissipation of the estate by Mr. Hettinger as he continues to travel internationally with him and his paramour, and the flouting of the court's order not to drink around the children, the flouting of the order not to have the paramour around the children, he obviously is just not interested in doing what the court has ordered him to do and not do. And he's bought 2 new cars. He's bought a Tesla, and he's bought a $100,000 Range Rover. And my client asked him to sign off on the back of her title so she could trade in her car to get a more economical car instead of more extravagant cars, and he refused.
Okay. Mr. Hull?
thank you, Your Honor. As you may recall, the last time you were telling them, and you talked to them both individually and told them how they were wasting tons of money by just litigating this. And so what the agreement was, and they made an agreement with you, and the agreement was that probably by the end of the year, we could get an evaluation of the businesses, get that done. Both parties agreed to be bound by that evaluation, and which we have received. We disagree with it, but we agreed to be bound by it. It's very slanted in her favor. But besides that, we already said that. And then we had an agreed order that the court put together. And again, that agreed order, when she talked about the support, it did say that, but then it said right after it, duration of support. It is agreed and hereby ordered pursuant to the agreement that the child support obligation of Andrew Hettinger shall continue until the mediation noted below. And he made those payments until the mediation, Judge. But even though there wasn't a temporary order on child support, he continued to pay the maximum child support. Then, Judge, also in that very same order, there's another provision, and I'll read that to you, that says duration of orders. These interim orders will continue in full force and effect until the mediation noted below, the continuation of the temporary order hearing, or until further order of this court, whichever comes first. He's been completely in compliance. With respect to their daughter that's gone to college, he's paid 100% of her expenses. There's one child that, since this case has been filed, she's already graduated, she's already in college. He's paid 100% of that. He's also had situations where he's had the kids over to his house. They've tried to text her, call her, anything to see if we can just stay a little bit later. She refused, and then she called the police on him and had the police come. She's got some anger issues, Judge. But what we're trying to do is just maybe get this whole thing resolved before Miss Lisa Taylor, Miss Klein, and I end up rich, and they end up completely broke. And that's what's headed for if we don't do it. What gave me some hope is when Miss Klein was out ill, the other attorney and Miss Hettinger basically said, we accept the second mediator proposal. We also accepted the second mediator proposal. I'm not a family law lawyer. I don't know if that's binding or not, because I know Rule 11 doesn't apply. It could be a mediated settlement agreement, and that's binding. But at any rate, all I know is, Judge, that both sides accepted it. Why not get back with Judge Alejandro and see if we can do it? Clearly, she also, Judge, I didn't interrupt. I didn't interrupt, Judge.
Hold on, Ms. Klein. Let him finish.
Judge, also, as we in one of our other motions pointed out that during this entire period of time, and remember, Judge, this was supposed to be completed by December of 2020. All 2021, it took a long time for those accountants to finally get their act together and give us a skewed resolution of what they thought the value of these companies were. But again, both sides agreed with Your Honor to go by whatever that was. Also, Judge, she received $800,000 as an advance towards any possible share of the community. She then received $400,000 as an advance of any property share of the community. He was paying that interim $10,000 a month for over a year, almost a year and a bit, Judge. Also, he also continued making for the automobile payments. He bought his daughter a vehicle. He's paid to have her fly down. He's done all those things. The trip to Iceland was a business trip, Judge, in which he got some good, substantial business. All of his trips have been business trips, Judge. And those are in the regular course of business because somebody's got to keep doing this to keep making money. He also, Judge, has had to take loans from the company, and this is monies owed by the community, to make her $10,000 payments and all the other payments. He also, during this period of time, she got to pay off her house. Also, during this period of time, her car was paid off. Also, during this period of time, he's paid the country club dues, the kids' expenses. She's had to pay nothing. And she's also got a master's degree and supposedly her own business. And even though the accountants were supposed to evaluate her business, they failed to do that. So basically, she's loaded with money. She's got all kinds of fluidity, not counting I think it's about $1 million that she took when she left, and I don't know whose advice, but she transferred money to her sole control prior to filing the divorce petition. But he continued to pay for the automobile insurance, the monthly payments on the daughter's vehicle. He's basically paying for everything. She's got no expenses, not even a mortgage, Judge. And then they're coming in here asking for more money when she's sitting on at least $2 million. So what we're asking, Judge, is that we think since both parties, when Ms. Klein wasn't around, both parties agreed to the mediator's second proposal. If there's some little quirk that needs to be worked out, let's do it. But why keep wasting everybody's time and money in the court's time? Done.
It's not a little quirk, Your Honor. What happened was that the mediator made a proposal, and then Mr. Holt took it upon himself to prepare an order or a mediated settlement agreement in which he substantially and materially changed the terms of the mediator's proposal. And then we get a series of emails from Mr. Holt dated October 1. Did the other side sign the mediated settlement agreement? Where are we on this? And then another one from Mr. Holt on October 5th from his assistant. Hi, Glendy. Did this case settle? I haven't heard anything. No emails, nada. How's Katie doing? Did she get through her surgery? Okay. And followed by October the 7th. Dear Judge Alejandro, is there any word? Was it rejected? If so, we'll continue with the case and get our motions on file. We need to know which way to go. Was there a deadline to accept your proposal? Obviously, they knew. We were not in agreement with the mediated settlement agreement that they provided, and we provided one of our own, and they refused to respond. So clearly, we don't have an agreement. But more to the point, Your Honor, my client has had to support herself and the children off of what was supposed to be her division of community property because he unilaterally stopped paying the $10,000 a month. If they believed that he was not required to pay it, there's no alternative amount in here. There's no step down. Nobody set $2,300 as the amount of child support. Granted, it said continue until mediation, but it doesn't say at which point this order expires by its own terms and she gets nothing. Obviously, they don't believe that because he started sending her $2,300 a month. In any event, for the last year, we've been trying to get a hearing on this matter. And I don't think that there's any way this case can settle because now the books are closed on 2021. We're now in 2022. And we have sent a request for him to provide us with the QuickBooks for 2021. We understand they had a pretty good year, but my client is not getting to share in any of the community income. And Your Honor is going to have to make some hard decisions here. And the fact that he could go buy a new Tesla, that he can buy a $100,000 Range Rover, that he can do whatever he wants instead of taking care of the children that live with my client, and that he's still drunk around the kids, and that he's still bringing the paramour around the kids, we need to have hearings, Judge. And we did submit you a list of our motions, and we need to have some transparency here. What is he spending? We believe that he's now paying Mr. Hole from Tex-Mex money because Mr. Hole has made an appearance in Paramour's divorce. Mr. Hole is spending his time at the request of Andrew Hettinger to defend Paramour in her divorce. Not only that, we have a copy of a check that was written from Tex-Mex Recycling to Mr. Hole, stating it was for services performed for SW Trading, which is my client's company. I asked Mr. Hole, what services are you performing for my client's company? He said, I never did. Clearly, Mr. Hettinger is using my client's company to try to write off attorney's fees for his divorce, when in fact, those are not deductible items. We don't have records of what all he's paying Mr. Hole, but we know he's paying Mr. Hole for services with Tex-Mex money. That's my client's money, Judge. In addition to which, he files a suit over in Ohio against my client, trying to establish that Tex-Mex is separate property, which is an issue that Your Honor is going to determine in this case. He also, in the suit that my client has brought against Ms. Hettinger, he's paying and got that case abated so that my client can't move forward with that case. He's just using the Tex-Mex money as his personal bank account to use all these funds to try to annihilate my client. And we have had a request for receivership on file for a long time. And we would ask that ATKG be appointed as receivers over this business and shut down some of the spending.
Judge, if I can respond, I think she's done. First of all, 90% of that isn't true about the cars, the doing this. He's taking care of the children, Judge. He's taking care of them. They have not wanted for anything. And if the court wants to talk to the children, which we would welcome the court do, they're fairly old, and they can certainly, the court can certainly talk to them and see who's taking care of them, who's the one throwing things at them, who's the one that's calling the police on their father, things of that nature. I'm not sure if the court's still there.
I'm listening.
Oh, okay, fine.
I went to my printer to get these that I printed.
Okay, and again, going back to the order and that you signed and that says it says specifically, these will continue in full force and effect until the mediation. So yes, he could have just stopped paying everything entirely. He could have, but he continued with the maximum amount of child support so that even though zero of that, in my opinion, is being used on the children, he continued to pay that because when the children have things, he's got a credit card they use, he's been paying all that. The children are well taken care of. This is I think I muted myself. Basically, what we're trying to do, Judge, is get this resolved so more of the community estate, if it is. Now, there was a lawsuit filed in Ohio because there is some question as to whether she even had a right to file a suit on behalf of the company since she doesn't own it. And Ms. Klein is incorrect about whether or not you will determine whether this is separate property. That's a jury issue. I'm not a family law lawyer, but I believe that's a jury issue as to whether it's separate or community property. And we think the jury will find, based upon the tracing of all the monies in this case, that not only is that his separate property, but so is all of these other companies, because Ms. Hettinger has already testified under oath, and she agreed that all the ones of the other companies were funded by Tex-Mex. But whether than go forward with the suits, and that was what the two proposals, Judge. One was X amount of money, and you go forward with the other lawsuits. One was X amount of money, and all the other lawsuits go away. She picked the one that she wanted to continue with the lawsuits. We also picked that one. And so why don't we just resolve it and get it? If the court were to look at my mediated settlement agreement and the judge's proposal, I know that, but they aren't different. She made it sound like it was completely different. It was not. And so maybe if we need to get Judge Alejandro, since we both agreed that we accepted the second one, get a mediated settlement agreement that meets the second proposal that both sides agreed to.
All right, here's what we're going to do.
I don't think this case is going to be settled, Judge, and I think
I'm setting it for trial. If y'all settle it before then, that's fine. You can settle it, and if not, we're going to try it. But my understanding is the only thing that was really set for today was a motion for enforcement. Now, were you seeking contempt?
Yes.
Criminal contempt, jail?
No.
Okay. So then we can go forward on that motion today, since you're not seeking criminal contempt and jail time.
But it hasn't been served, Your Honor, so he has a defense to it.
Oh, and plus the judge, if you look at your order, it specifically says they will only continue until the mediation. That's what your order says.
Okay.
No, it
well-
does not say only. It does not say only.
Okay, hold on. So this is what we're gonna do now. We're going to, and I'll start with, the first one I have is the Holland Alvarez letter of the motions pending in connection with the matter that you want heard. And that's a motion for reconsideration of the agreed interim temporary orders, right? You want to have another temporary orders hearing, which I know I promised y'all. If you
No.
did reach an agreement at mediation, we would have that. And I wanted to have that right after the mediation, but we didn't. Okay, so we're going to do that. Revisit temporary orders. Ms. Klein, it sounds like you're in agreement with that because you want to revisit those issues as well, right?
Well, I think that the orders need to be clarified. I
Okay,
think
well,
that,
we're going to make them crystal clear, okay? So the second thing he mentions is a second motion for the court.
Your Honor, not to be rude, but you notice that he says that that temporary order is now moot. So he apparently thinks that taking the kids around the Paramore, spending money, and all the things that he's
Fine,
doing
we're
are moot.
You can argue all these things when we come back, okay? And
Thank
as
you,
far
Judge.
as what I ordered and how clear I was, I remember how clear I was. So we'll deal with that when we get to that hearing. So something about second motion for the court to order petitioner to attend anger management classes.
Yes, Your Honor. And it's even gotten worse since then, so.
Okay. So
Well, his motion says that in 2019, my client lost her temper at mediation, which is mediation protected, privileged, and confidential. So talk about moot. That's 2 years ago.
well, regardless, and you're not going to tell me about anything that happened at mediation, but I'll take up that motion, and if they have any evidence to support it, well, then they may have it granted in their favor, and if not, well, then they won't. But we're going to take up that motion, okay, Ms. Klein? Okay, Mr. Hull?
Yes, Your Honor.
Sure.
We're also going to take up this respondent's emergency motion to compel filed on August 18th. What was that motion to compel for, Mr. Hull?
The production of documents, Judge, so that we could, respond timely and have them before the mediation. But we still have a plethora of documents that have not been provided. On the day of
Okay.
mediation, she did bring a box full of stuff, but it was mostly duplicates.
Okay, so we're going to hear that motion as well, to the extent that there are still documents that you are wanting covered under that motion, okay?
Yes, Your Honor.
Fine, are we clear on all that?
Yeah, I'm going to file a cross motion to compel only because they will not provide us with the 20.
Hold on. We're not done. Okay. Now let's go through your list.
Okay.
Okay. Number one, emergency motion to compel production of key man life insurance policies and other documents necessary to complete evaluation. Do we still need that?
Yes, they will not provide us with the key man life insurance policies. We have a belief that there's multi-million dollars going into that.
So we're gonna hear that motion. The second, are you clear, Mr. Hull? We're gonna hear that one.
Yes, Your Honor.
Ms.
But these are
Klein,
term
The
policies.
next one is petitioner's first amended emergency motion to compel production of key man policies and other necessary for the evaluation and mediation. So isn't that the same thing?
Yes, Your Honor.
It's an amendment, so it's more complete than the first one.
Okay, well, whatever the most recent amended version of that motion is, we're gonna hear, okay?
Okay.
Okay, petitioner's motion for appointment of receiver. We're gonna hear that. Are we clear, Mr. Hull?
Yes, Your Honor, but that's going to be a rather long hearing because we're going to have to be.
That's all right. I just want to make sure both sides understand what all we're going to hear at the next hearing so that there's no question about, well, I haven't been served. I wasn't notified. I wasn't this or that. No excuses. Okay.
Okay.
Next, we're going to hear petitioner's motion for production of sworn inventory and appraisement. We're going to hear that one. Okay, Mr. Hull?
Yes, Your Honor.
We're also going to hear petitioner second motion for enforcement of support order.
Yes, Your Honor.
And we're also going to hear petitioner's motion for production of the 2021 QuickBooks.
Well, Judge,
right.
that one was filed at, and I will
don't
have
care
to,
when it was filed. You've gotten a copy of it, right?
Judge, if I could respond.
We're not hearing it today. We're going to hear it in the future. Okay.
Judge, could I respond?
Sure.
Yeah, my understanding from speaking to Ms. Pettis was we were supposed to say what motions were already on file, because we've got a plethora of a bunch of motions we could file, but we thought the case was settled. And so why waste the money and time filing those if we're going to get resolved? So we may have other motions too. She filed that on the day she filed the letter with the court.
Well,
So
if you have other motions, that's fine. But this is what we're going to hear as of this date that I'm going to give you. Okay.
Yes, Your Honor.
All right.
Now, Jackie, are you all doing in-person hearings yet?
We can, Judge. We just have to make sure on our calendar that we have availability for in-person with a court reporter.
Okay, and it seems like this is going to take quite a bit of time. I'm thinking it's probably going to need to start in the morning and maybe carry over into the afternoon.
Yes, Your Honor.
I agree.
So what days do you have available, Jackie?
Judge, can I look into my calendar and you want me to send you a message first so you can double check on your calendar, or you want me to show you?
Well, I'll have to check with Priscilla.
Okay.
And I'd like to get this done in the next 2 to 3 weeks if we can. Okay. How do Fridays look for y'all?
Well,
Fridays are good for me, Judge.
Ms. Klein?
My son is getting married in North Carolina on the 4th of February, so I will be out from the 1st to the 4th. So that Friday's definitely out. Let me look at the other Fridays in February.
Thank you, Margie.
And the 11th,
I'm going to be out. I'm sorry, I'm going to be out the Friday of the 11th and returning on Monday, the 14th. I'm going to be out of the state.
Judge, I'm also busy on that day, but I have the 18th and the 25th both full open.
Jackie, do you have the 28th available?
28th is a Monday.
No, January. If we can hear this next week, we'll hear it next week. You don't need to wait till February.
Judge, I'm in depots in Dallas on that date, in-person depots.
What do y'all have Monday the 24th? Jackie, can you do Monday the 24th?
Judge, we have docket in the morning and the afternoon.
Okay.
And I'm also have hearings, Judge, all day.
So
well, not all day, all morning.
What day works best for you, Jackie? Let's start with that.
Judge, we have available January the 28th. All day.
Hall, what about you, Ms. Klein, on the 28th? Are you available?
I have a deposition that just got quashed, so I think I'm fine.
Mr. Hull, is there any way you can reschedule your depots?
No, Judge, they were rescheduled once before, and these are two experts flying into Dallas for the depots, and it's already been
Ms.
set.
Taylor, can she handle these hearings?
I think we both need to be there, Judge, especially if it's in person. And
We do, Judge. Mr. Hull's been basically lead on 99% of this stuff to keep the billing down.
All right. So what about the 27th, Jackie?
I have court all day, Judge. I mean, if you're available February the 4th.
Problem is Ms. Klein's out of town or out of state.
My son's wedding.
Okay.
What about the 11th?
The 11th, we actually have another case with Ms. Klein. If Ms. Klein recalls Ms. Solano's case.
Yeah, that's with Judge Huerta.
Yes.
Is that going to take all day?
I have no idea, but it could.
Judge,
What
February
about-
18th is open. That's the
February
next Friday.
18th, I have a hearing with the same case, Ms. Solano's with Ms. Katie Klein.
Two
Oh,
different-
actually, you know what, Jackie? I'm noticing the 18th is the hearing date. The 11th is just a conference to talk about what's left to be heard. So the 11th, I can be there.
Okay, well, I would just need to get in contact with with Judge Huerta to see how long it's going to take the informal hearing.
Judge, I'm going to be out of,
I'm not
gonna be-
available the 11th.
yeah, and I'm going to be out of town.
I'm sorry, what about the 17th of February?
I'm actually at a judicial conference, so I can't do it that day. What about Mondays?
Monday, the 21st is open.
The 14th
That's President's
to the
Day.
7th?
The county it's a holiday in the county.
The 22nd. The 25th, that Friday, I'm open.
No,
February
You
25th.
can do it the 25th. I hate to push it that far off, but does that work for you, Ms. Klein?
Does, Your Honor.
Okay, so the 25th.
It works for,
Judge, if I may, on the 25th of February, the Court 8 has a deed of arraignment docket, but we're usually done by like 10:30 in the morning. Is that okay if we start?
That's fine. We could start it. We'll just say 10 o'clock so that
Okay.
we could be ready to go and
Perhaps
if you're
work through
done
lunch.
early, we can work through lunch or take a quick lunch or whatever.
Okay, so February 25th, at what time? At 10 in the morning?
10 a.m.
Until finished.
Right. And it'll be all these motions that I pointed out. Okay.
Yes, Your Honor.
Now, as far as trial, how long before y'all are ready for trial?
sorry, Judge, can I
March,
ask, before we talk about that, can I ask one question, Your Honor?
Sure.
What generally happens is when the court sets a hearing for XYZ pending motions, then Ms. Klein will file 10 more motions between that date and the date of the hearing. So is there a cutoff of date
We're only
as to
going to
when you
hear.
can file any motion?
We're only
These are
gonna
the
hear
ones we've already
motion
talked about.
that I talked about. Okay. Is there anything else, Mr. Hull, that you have not filed that you need heard by that date?
Not necessarily by that date. I understand, Judge, we want to be able to get the hearings all done. So that's why I think we need to limit them to a reasonable one. We do have other motions to file, but I will.
I understand, but in all fairness to you, she has 6, you only have 3 there. So trying to
Well,
be fair to you as well.
Fine, Judge. And if we have any other motions to file, we will file them by next Wednesday and get them set for the same date.
But I understand we're not adding on motions, correct, Judge? We do have
Well,
5.
that's why I asked him what else, if anything, he might need heard, because you have 6 things that I'm hearing and I'm only hearing 3 for him.
It's
I
actually
would like
5,
the
Your Honor,
opportunity
because
to
1 and
confer
2 are
with
the
Mr.
same.
Cole I would like the opportunity to confer with my co-counsel on what motions, if any, we would need to file. And if you could just give us a deadline of next Wednesday to do so, that would be fine.
I'll
But Your
tell you
Honor, I
what,
do want to clarify, we have 5, not 6, because 1 and 2 are the same, except they're
okay.
amplified.
All right. Well, I'll tell you what. I'll let you file 1 additional motion, and I'll give you until next Wednesday to file it to be heard.
Thank you, Judge.
Okay. And that's for Mr. Hull's side, not Ms. Klein, because we already have 5 for you. Okay.
Yes, Your Honor. The one thing I would ask, and I don't think this should be difficult, is that they did an appraisal of my client's personal property in her house. She opened her house for them, and they did an appraisal of her jewelry, but they will not provide us with the appraisals. And I'd like to ask that Mr. Hull please provide us with the appraisals of my client's possessions.
Well, that would be
Didn't they do
under
the property?
these,
They did their jewelry. The appraisal that apparently got completed was the one of the jewelry, and we would like to have a copy of their appraisal.
well, they have to, I mean, it's under number 4, inventory and appraisement. I mean, that should already be
Correct.
part of that. And that should have been, textbook from the beginning, and y'all need to supplement as you go.
Yeah.
So.
And Judge, don't take what she says is necessarily true. I am sure okay. I'm just saying.
It should have been done, and it probably did get done. And if it didn't, I'm sure you're going to get it done. So we don't have to argue about it on that day. But in any event, now, how soon can y'all be ready for a jury trial?
I said March.
Summer.
March, Judge.
Why do we need to wait until summer, Ms. Klein?
Well, Your Honor, first of all, I still have 1 hour left of Ms. Murray's deposition. I have a feeling that Mr. Reynolds is going to fight me on that. Mr. Hull is going to fight me on that. So we're going to have difficulty with that. But Your Honor, we had taken 5 hours. We have 1 hour left. In addition to which, If we're going to get the 2021 QuickBooks, we're probably not going to get them. Your Honor's going to order them, and then it's going to take them a month or two. They're going to say they're incomplete. It just takes a long time in this case to get anything from the other side. And I want to have a date certain that we're going to go.
Judge, first of all, you don't get to piecemeal depots and say, I'm going to take 1 hour here. She completed the deposition, whether it took 5 hours or 3 hours. Second, Judge.
They walked out and we had a hearing on it and you ordered that I had 1 more hour.
Excuse me, Your Honor, I didn't interrupt for the court reporter. Let's try to talk one at a time. Anyway, Judge, and she had to take it by a certain date and time, and she didn't do it. With respect to, and she's no longer a party, Judge. She was a party at that time.
She's a fact witness who's critically important.
Judge, again, she keeps interrupting. Could the court maybe instruct her to not interrupt?
Go ahead, Mr. Hall.
Thank you. And so, and with respect to the QuickBooks, we don't need any of that because both parties agreed to be bound by the appraisal that was done by the accountants that the court chose. So that's already been done, Judge. So I think a March date would be, this case just needs to get tried so these people can go on with their lives and let a jury decide whether this was separate property, whether she's entitled to. I don't think there was a problem with the custody. I think both sides agreed on that, but you know, whatever. Let's just get it tried.
Okay.
Your Honor, we have a claim for reconstitution of the community estate, and our reimbursement claim relates to the excessive spending of Mr. Hettinger. And so without the QuickBooks, we cannot determine what all he's spending. He is bleeding the company in order to dissipate its value by buying life insurance policies on minors, because he's trying to put as much money as he can in a place where my client can't access it. And he wants to tell you he's caring for the children. He still has a wife. He's caring for a paramour, but he still has a wife.
Which has 1.2 million plus the 1 million she took with her when she left, Judge. He
has no idea what she has.
We can argue about all this stuff on the 20, what did we say, 24th?
25th, Judge.
All right,
Yes.
So.
The sooner we have a trial, Judge, then the sooner Ms. Klein can stop complaining about what Mr. Hettinger spends, and Mr. Hettinger can live his life, and Mrs. Hettinger can live her life. And we need to get this over sooner rather than later. It's
I'm
dragged
going to
on
find
long enough.
a trial date for you in May or June, because that's summer. End of May, beginning of June, Miss Jackie. Can you find something?
End of May, you said, Judge?
And end of May, early June, just so we can get it done.
I have a trial set May 23rd that can probably get bumped, and I'm open May 30th.
Judge, for our calendar, because we have our jury calendar going on, right now I have available for trial on June the 13th.
June 13th? Okay, well then that's when we're going to have it, if that's what you have available. June 13th, preferential setting.
Judge, I already have 2 cases set in the 139th on that date. I didn't have trouble double booking because I know only one will go.
How old are those cases?
Let's see, Del Sal. Well, one of them is probably about 3 years old, and the other one is probably 2 years old.
Older than this?
Yeah, I think one of them is, yes.
And is that the first setting on that one?
No, it's like the third.
Okay.
Well, Judge Wattis wouldn't object if you had a specially set trial.
Well, and he has a criminal docket, and right now we're going to be so backed up with criminal cases that they're going to take preference. And if there's availability in this court to have a trial that week, well, then I just want to jump on it before we lose it.
Is there any availability in May, in the month of May for this case?
If the court has June 13th, Judge, we're okay with it.
I don't know.
If you don't have a conflict, Ms.
Jackie,
Klein.
do you have anything in May, Jackie?
Have May booked for trials, Judge.
May 12th? Keep in mind, if I give you May 12th, that means when they're asking for different things to be produced, y'all need to produce them timely, early, or don't be upset when that trial gets bumped again and your client's paying child support and spousal maintenance.
Okay.
May 12th
is a Thursday. It's not a Monday. So do y'all have jury panels on Thursdays?
No.
Jackie?
I have I believe it's Mondays and Tuesdays, Judge.
Jury trials Mondays and Tuesdays?
Correct.
Jury panels.
Okay, so what's that Tuesday? She's saying it's the Thursday's the 12th. Would it be May 10th?
I have available May 10th.
I'm open May 10th, Judge.
That would be, or the 16th would be the next Monday.
May 10th is open, Judge.
For our docket, Judge, May 10th works for us.
Ms.
I
Klein?
have a trial on May 9th, but I can just, and it's old, it's a 19 case, but I can work with that court if that's what needs to happen.
Judge, I have a jury trial set for May 10th, but I don't think it's going to be a conflict with this case because you're the judge, so I'll be wherever you tell me to be.
Sounds like May 10th works.
Hold on, give me 1 second. I need to check something real quick because I need to make a real quick phone call to make sure I'm not conflicted that day.
We will stand by.
Okay. Looks like I'm clear for May 10th, the week of May 10th. And what I'd like to do is keep that June date, keep it on your calendars. I know you were set in that other, in the 139th, Mr. Hull, but we're going to keep that date here as well as a backup. That way, just in case anything happens to May 10th, it will be tried in June.
Okay,
Sorry, what was the June date? I'm sorry, Judge.
I think it's
13.
13th.
Should we call it the 9th or call it the 10th, Jackie?
Whatever that Monday is.
That's the 9th.
Can we do that, Jackie, or
I'm sorry, what was that, Judge?
Tuesday's the 10th. Can we do it the 9th, or does it have to be the 10th?
Well, that's the only thing that I was calling you about, Judge, that we're set to start trial like in our court. If there's any conflict of us going into the trial, as far as our court reporter, we would just have to look for another court reporter. That's the only issue.
Okay, so we'll set it for the 10th in the morning at 9 o'clock. And we'll work late if we have to that week to get it done.
And the backup date of June 13 also at 9 a.m.,
Correct.
Your Honor?
Correct. And I know that it doesn't sound like there's any hope for reaching a settlement agreement, but to the extent y'all want to go back and visit with Judge Alejandro, I'll leave that up to you. I'm not going to order it. All right. Okay,
Yes, Your Honor.
so that's what we're going to hear, plus one motion that Mr. Hull will file no later than next Wednesday. We'll set that for the same date as well, plus these other 8 motions that we mentioned today in court. All right.
Yes, Your Honor.
Yes, Your
Thank
Honor.
you, Honor.
All
Thank
right.
you.
Y'all have a wonderful day.